Hello and welcome to this webinar on adoptive couple versus baby girl. As hopefully this is a case involving the Indian Child Welfare Act that was heard by the United States Supreme Court. It is the second case that the United States Supreme Court has heard that specifically deals with the Indian Child Welfare Act since the passage of the Indian Child Welfare Act in 1978. Okay, let's get started. In order to ensure that everybody can follow along with the factual background and then some of the legal issues involved in the case, let's first go through and explain who the people are that are most involved in this case. Baby Veronica is a child who is born in Oklahoma. She is a citizen of Cherokee Nation. Her father, Dustin Brown, also a citizen of Cherokee Nation, lives in Oklahoma as well. Her biological mother, Christy Maldonado, is not Native American, also lives in Oklahoma. The adoptive couple are folks named Matt and Melanie Capobianco, and they are non-Indian and live in South Carolina. The fact that Veronica is born to biological parents in the state of Oklahoma and then adopted later in South Carolina comes into play a little bit later, so keep those facts in mind. And again, her tribe is the Cherokee Nation. So this is a case that in the news you've probably heard really revolves around the Indian Child Welfare Act and is the case that has really challenged the Indian Child Welfare Act most directly since it was passed in 1978. So let's talk about how ICWA applies. ICWA applies to a variety of child custody proceedings, both involuntary and voluntary. It applies to this case specifically as a voluntary relinquishment case, meaning that baby Veronica's mother gave her up voluntarily for adoption. So in addition to determining what kinds of cases ICWA applies to, meaning what kind of child custody proceeding, and in this case we know that because it's a voluntary relinquishment case that ICWA would apply if there's an Indian child involved. And Indian child is specifically defined within the Indian Child Welfare Act and includes a person who is either a member of a tribe or a person who is eligible for membership and who has a biological parent who is already a member of a tribe. So in this particular case, biological father, Dustin Brown, is a citizen of the Cherokee Nation when this case unfolds. And the citizenship criteria within Cherokee Nation is based on lineal descendancy. So Veronica, his biological daughter, is automatically eligible for citizenship within the tribe. And it's important to understand here that tribal membership is a purely tribal determination, that state courts, federal courts, the Bureau of Indian Affairs, any other entity has no jurisdiction to review tribal membership determinations. Again, that is exclusively left to tribes. It's important also to understand before we leave this slide that Veronica's blood quantum is absolutely irrelevant to this case. That Veronica is a citizen of the Cherokee Nation based on Cherokee Nation's citizenship criteria, which is again based on lineal descendancy, just as she is a citizen of the United States of America. Okay, so what's the intention of the Indian Child Welfare Act? Well, the intention is to keep Indian children with their tribal families and their tribal communities. It's to prevent the unwarranted removal of Indian children from their homes and to protect tribes' most sacred and important resource, their children. And this is achieved through minimum federal standards, including things like placement preferences, that the federal government requires state courts to adhere to in working through child custody proceedings where the ICWA applies. Okay, so let's get into the factual background of this particular case. Here we have Dustin and Christy knowing each other since they were about 16, dating on and off in high school. In 2008, Dustin joins the Army. Christmas of 2008, Dustin actually asked Christy to marry him. About a month later, Christy tells him that she's pregnant. We don't know exactly why things didn't work out, but eventually Christy sends Dustin a text message asking if he would sign over his rights. At this point, Dustin has no knowledge that Christy is intending to relinquish the baby for adoption. He just thinks that she is essentially asking for sole custody. It's really important to understand that Christy never tells Dustin that she intended to put the baby up for adoption, and the South Carolina Supreme Court documents this on page 3 of its decision when it affirms a lower court decision to keep baby Veronica with her dad. Dustin actually doesn't even learn about the adoption until baby Veronica is 4 months old. She's living with the adoptive couple already, and he is served with papers just before he is about to deploy to Iraq. So this is a quote from the South Carolina Supreme Court decision having to do specifically with what happened when Dustin was served with papers. Again, when baby Veronica is 4 months old, already living with the adoptive couple. He has no idea about the adoption. Process server shows up and asks him to sign papers. So here is what the court has to say about all of that. A process server presented father with legal papers entitled Acceptance of Service and Answer of Defendant, which stated he was not contesting the adoption of baby girl and that he waived the 30-day waiting period and notice of the hearing. Father testified he believed he was relinquishing his rights to mother and did not realize he consented to baby girl's adoption by another family until after he signed the papers. Upon realizing that mother had relinquished her rights to appellants, father testified, I then tried to grab the paper. The process server told me that I could not grab that because I would be going to jail if I was to do any harm to that paper. So clearly, Dustin has no idea about the adoption. When he figures out what's going on with the papers that he signed, that those papers aren't just providing sole custody to Christy, but really are relinquishing his child for adoption, he tries to grab them back and is told by the process server that he's going to go to jail if he does that. So January 6, 2010 is the date that Dustin is served with the papers, that all of that happened. Dustin immediately seeks legal counsel. That initially he does this through the military because again he's in the Army. The next day though he hires private legal counsel. And here's where the legal portion of this case really begins in earnest. So January 6th he's served with papers, seeks legal counsel right away. By January 11th Dustin requests a stay of the adoption proceedings under the Service Members Civil Relief Act. And on January 14th, he files a summons and complaint in an Oklahoma district court to establish paternity, child custody, and support of baby girl. So as soon as Dustin is figuring out what's going on with his child, he's moving very, very quickly. So then on January 22nd, the adoptive couple files the papers that they had served on Dustin back on January 6th, right? The papers that Dustin signs and then tries to grab back and the process server says, you can't do that or you're going to jail. Adoptive couple files those, and again, those are the father's acceptance of service, an answer stating he is the biological father and not contesting adoption. So many watching this webinar have probably asked yourself the question of, well, where is the tribe up until this point, right? That if baby Veronica is 4 months old in January when dad is served with the papers, certainly the tribe should have received notice of the voluntary relinquishment proceeding. And that is absolutely true. The tribe should have received notice. Unfortunately, the tribe received a letter in August of 2009 that contained inaccurate information that led the tribe to believe that Veronica was not actually eligible for citizenship within the Cherokee Nation because Dad's first name was spelled wrong and his date of birth were wrong, which is why it's so critical that information contained in those notices be accurate, because it really precludes the tribe its right to be able to intervene in these cases and protect its children. Cherokee Nation in this particular case doesn't intervene until March 30th of 2010, and at that point, from that point going forward, is a very active party in the case. So the trial court has this case up until a decision is entered in November of 2011, and at that point the family court judge issues a final order finding that the father did not involuntarily consent to the termination of his parental rights or the adoption, that the appellants, the adoptive couple, failed to prove by clear and convincing evidence that father's parental rights should be terminated, or that granting custody of baby girl to father would likely result in serious emotional or physical damage to baby girl. And that father, despite some early indications of possible lack of interest, not only reversed course at an early point, but has maintained that course despite active opposition from the prospective adoptive parents. The court also found that Dustin was a good father who enjoyed a close relationship with his other daughter, and that he and his family have created a safe, loving, and appropriate home for Veronica. The court also found no conflict between recognizing the father's parental rights and the best interest of Veronica. So as you can guess from that language, the South Carolina trial court did return Veronica to Dustin, and many of you have likely seen in the media the picture of Dustin driving into town around Christmas time in 2011 to pick up Veronica in his pickup truck. The adoptive couple almost immediately appealed to the South Carolina Supreme Court, and the South Carolina Supreme Court affirmed the trial court decision, meaning that even through the South Carolina Supreme Court decision, Veronica gets to stay with her dad. The South Carolina Supreme Court, in its decision, documents a number of errors that had happened in this case along the way. One of the errors that it documents has to do with a law called the Interstate Compact for Placement of Children, that's often referred to as the ICPC. And it applies when you have children that are crossing state lines as the result of some kind of child custody proceeding, including, as in this case, an adoption proceeding. And that here, because we have Veronica being born in Oklahoma, but then needing to be moved to South Carolina because that's where the adoptive couple lives, the ICPC process had to be followed. Unfortunately, the application, which would have been filled out by the adoptive couple, or more accurately their legal counsel, was not filled out properly. That it should have specifically included that she was Native American. And had it included this information, chances are very, very likely that she never would have left Oklahoma and would never have had to go through the trauma that she has experienced in her very young life. These legal safeguards, though, they only work when accurate information is provided, right? It's the same thing as what happened with the notice to the tribe, right? That as we talked about, the notice to the tribe in 2009 misspells Dad's name, provides inaccurate date of birth for him, which ultimately leads the tribe to initially not know that they have a child involved in a voluntary relinquishment case. That these errors, which are supposed to be safeguarding the rights of children, are allowed to occur is very, very problematic. And so the South Carolina Supreme Court, though, does a great job in calling them out in its decision. So once the South Carolina Supreme Court issues its decision, which again allows Veronica to remain with her dad, the adoptive couple appeals to the United States Supreme Court. And unfortunately, at the United States Supreme Court level, Dad loses Veronica to the adoptive couple in a 5-4 decision. And that decision is, it's a very narrow decision. There are a number of places within the decision that document that it's being decided on essentially the most narrow basis possible. It addresses 3 separate sections of the Indian Child Welfare Act as they apply to private voluntary adoption cases. Those 3 sections are 1912F, having to do with termination of parental rights, 1912D, having to do with the active efforts requirement to prevent the breakup of an Indian family, and 1915A, having to do with adoptive placement. So let's go through each of those. So 1912F, and again, these are all sections of the Indian Child Welfare Act as it was passed by Congress in 1978. So 1912F has to do with termination of parental rights. And it says that termination of parental rights cannot be ordered unless there's a finding beyond a reasonable doubt supported by testimony of a qualified expert witness that continued custody, and that's a phrase that the United States Supreme Court really keyed in on, is continued custody, that continued custody of an Indian child by a parent or Indian custodian is likely to result in serious emotional or physical harm to the child. So the United States Supreme Court finds that 1912F does not apply when the Indian parent never had custody of the Indian child. And obviously the court is not looking at the period of time when they are actually hearing the case, that instead they are looking at and considering this period of time essentially when Veronica is born and the initial adoption proceedings are happening. It's problematic because of course at that time the tribe wasn't noticed properly, and Dad didn't even understand at that point that his daughter was being put up for adoption. So certainly this decision does not set well within Indian country, but here's where we are. The court included a discussion of how the Indian Child Welfare Act was intended to prevent unwarranted removals of Indian children from their home, and pointed out that in this particular case, because it's a private voluntary adoption, right, where mom is voluntarily giving the child away and dad theoretically through a text message, because that's how we give away children in this country, is via text message, because it's a voluntary adoption, that there's no unwarranted removal, that it's not a situation where the state or the county is coming in and forcibly taking children and adopting them out to non-Indian homes. So that was the rationale behind the court's interpretation of 1912F, and fortunately, again, the decision is narrow in that it seems to apply very specifically to private voluntary adoption cases. The U.S. Supreme Court decision also includes a discussion of ICWA at 1912D, having to do with active efforts, stating that any party seeking a foster care placement or termination of parental rights must make active efforts to provide remedial services and rehabilitative programs to prevent the breakup of the Indian family. And it's really that last phrase that we're going to see the court look at. So what the court does is that it essentially says that this section doesn't apply, that dad was not required to have been provided active efforts to prevent the breakup of a family, because it doesn't apply where an Indian parent has abandoned the child prior to birth because there's no breakup of a family at that point. Again, really looking at this case as being factually and legally different from sort of your typical foster care cases. Again, really analyzing it based on it being a private voluntary adoption case. The court also includes a discussion of 1915A, which is the section of ICWA dealing with adoptive placement preferences, and provides that in the absence of good cause to the contrary, adoptive placements of Indian children must be made in the following order of preference: a member of the child's extended family, other members of the Indian child's tribe, or other Indian families. So in a case where an Indian child requires a placement, placement should be made first with the child's extended family. And if there is no extended family available, then you would drop down and look at another member of the child's tribe. And if there's no person that's a member of the child's tribe that's available, then you look at other Indian families. That, of course, did not happen in this case. That ICWA technically should have applied to the case because ICWA applies to voluntary relinquishments, and that Veronica is an Indian child within the definition contained within the Indian Child Welfare Act. However, she is placed with non-Indian adoptive couple, so the Supreme Court had to deal with this particular section. So let's look at how they do that. The court finds that 1915A just simply didn't apply because no other person had formally come forward to adopt the child. They do make this ruling narrow, as they did with the other two sections, in applying it very specifically to voluntary adoptions, but it is still extraordinarily problematic, again, from a tribal perspective, because this is a case where the tribe doesn't get proper notice, so doesn't know that this case is even happening to be able to locate extended family. This is a case where dad is under a mistaken assumption that mom is going to be taking care of the child through sole legal custody, has no idea that the child is even going up for adoption. So for the court to then rely on no other person having formally come forward to adopt the child is, again, to say the least, troubling. This was a case, though, that caused just tremendous stress for those that practice both federal Indian law in general, and certainly anything having to do with the Indian Child Welfare Act specifically, because the adoptive couple was actually challenging the constitutionality of ICWA as being a race-based statute. And those that practice in federal Indian law are certainly very well aware that ICWA is not a race-based statute, but is in fact based on a political relationship between tribes, federally recognized Indian tribes, and the United States government, and that it's through that unique relationship that Indian tribes are sovereign political entities. And the court didn't address the constitutionality issue at all in the decision, so ICWA remains constitutional, tribes remain sovereign entities, and we go forward, we continue to go forward, understanding that ICWA and other federal Indian laws are again based on this very unique political relationship between tribes and the United States government, and are not race-based statutes. So what are the takeaways from this case? Well, the first takeaway certainly is that it was just an absolutely heartbreaking case. Even in putting together the webinar, we were reminded of just how devastating this case was and how it continues to be felt. And that in terms of practice that the Supreme Court's decision is narrowly dealing specifically with this particular private voluntary adoption and should not then spill over into foster care cases having to do with children being removed due to abuse or neglect. And that we, in February of 2015, get updated BIA guidelines that provide clarification from a federal level on the entire Indian Child Welfare Act. And so that has been tremendously helpful in ensuring that this decision is treated in the narrow fashion that it appears to have been intended, and also that state courts have additional guidance on how ICWA was intended to be implemented on a state level. We have prepared a separate webinar specifically on the February 2015 BIA guidelines that's available on our website for free viewing and download. So thank you very much. We hope that this has been helpful. Contact information is here. Also, there are a number of other webinars and additional informational packets available on our website. We hope that this information proves valuable to you in your practice. Thanks again.